Hi there. Today's mini lecture is on the Bill of Rights. This is an amazing number of amendments. The Bill of Rights contains the first 10 amendments to the Constitution of the United States. The Bill of Rights wasn't written at the very same time as the Constitution, but it came in as a result of the very first Congress of the United States in 1791, Bill of Rights, first 10 amendments, be sure you get that down, and they were written by James Madison. And we all know James Madison was called the father of the Constitution. As the states ratified the Constitution, many of them were upset and afraid that this new strong central government that they created with the Constitution would abuse citizens of the country. And so they needed a Bill of Rights, they felt, that would protect us, citizens, from the powers of the federal government. And so in 1791, the Bill of Rights were added to the Constitution in the time-honored method of adding things to the Constitution. And they're super, super important for us today. I'm going to give you a brief overview, as brief as I can, because there's so much material here. You've had books and tomes and libraries written on some of the cases that deal with the Bill of Rights, but they're so important to you and to me. The First Amendment says this to the Constitution. Number one, it has 5 freedoms in it. They're called the First Amendment freedoms, and they're very, very important. Some people think that the First Amendment freedoms are the most important parts of the Bill of Rights, because if you lost any one of these protections and guarantees, you would know it right away. They are freedom of religion, speech, press, assembly, and petition, 5 of them. And the language of the Bill of Rights says this: Congress will make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Now that's all it says. It's pretty short, it's pretty sweet. But think of the cases that have been litigated over freedom of religion. What does it mean, Congress will make no law establishing a religion? Or what does it mean? It really mean Congress can't prohibit the free exercise of your religion. What if your religion or your God requires human sacrifice? Can Congress restrict that? That type of case goes to the Supreme Court. Fascinating cases on religion: speech, press, assembly, and petition. And then these right here, amendments 4, 5, 6, and 8, are the amendments called the due process guarantees. These are so important to you and to me, because if we are ever accused of a crime, then we're going to go right, and our lawyer is going to go right to the Bill of Rights in amendments 4, 5, 6, and 8 to see how we are protected against government. So let's have a look at these. Let's look at number 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the things, persons, or things to be seized. So that's pretty specific. If you're making a list of what your rights are, be sure you get all of those. No unreasonable searches and seizures shall be made. If they're going to search your place, they've got to have a warrant. And what has to be on that warrant, or they can't use it. So in 4, then you have no unreasonable searches and seizures. But again, what is unreasonable? And that's for the Supreme Court to decide. Remember, the court tells us what the Constitution means and what it means not, in that very archaic language. But look at this. In your text, it's talking about something called the exclusionary rule. In a case that came to the Supreme Court in 1961 called Mapp versus Ohio, in this particular case, there was a woman who lived in a home, and the police had been watching her home for a long time, and she was suspected of dealing in booking and betting on horse races and stuff like that. So they came to her house without a warrant and entered her home and found evidence which was used to convict her of bookmaking and betting on horses. She appealed the case, and she said, my rights under the Bill of Rights, this amendment, were violated here because they didn't have a warrant, and the Constitution says if you're going to seize anything, search anything, you've got to have a warrant talking about who you're going to search, the things, the places, the persons to be seized. And the court agreed with her. And it said, it went a little farther. It issued what we call the exclusionary rule, which says if evidence is ever collected and they forget any one of these amendments and these guarantees that we have in the amendments, then they can't use the evidence in court against you. That's the exclusionary rule. That's what it means. And it came from this case, Mapp versus Ohio, in 1961. Let's look at the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. All right, what is indictment by a grand jury? This is an added protection that we have. If you're going to have a jury trial, generally it will be called a petite in French. A petite jury, they call it in Texas a petit jury, because we're in Texas. A petit jury, which means a small jury, a regular jury of 12 people. But a grand jury, or in French, grand jury, a big jury, could be as many in some states as 24. And this is a different jury. It's not trying to look at the evidence to see if you're guilty or innocent. It's simply trying to look at the evidence to see if there's enough evidence there presented by the government to even have a trial. If they believe that there is enough evidence to have a trial against you, they will issue a bill, a true bill of indictment, I-N-D-I-C-T-M-E-N-T, a true bill of indictment. If they think there's not enough evidence to have a trial, then they issue no bill of indictment. And if you read in the newspaper about Dallas County Grand Jury met and they issued 24 indictments and 15 no bills. A no bill means in 15 cases they found there was not enough evidence to have a trial. That is another guarantee and protection for us against the abuses perhaps of government or of police. Okay, so let's go on in 5. No person, that would be you or me, can't be subject for, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. That means no double jeopardy. That means you cannot be tried twice for the same crime. If you are found not guilty in a criminal case, and you walk into the lobby of the courthouse and say, "Ha ha ha, I'm guilty, I did it," they can't try you again. This is really to keep government from harassing you over time, over and over, and bringing you back and back to trial after you've been found not guilty. Nor can you be compelled in any criminal case to be a witness against yourself. That means you have the right to remain silent. All right, there are two, well, let's keep going and then I'll talk about that in a minute. You cannot be deprived of your liberty, or your property without due process of law. What is due process of law? All these things right here. 4, 5, 6, and 8. That's due process of law. They can't take away your life, your liberty, or your property unless they hit every single one of these guarantees. Think about the exclusionary rule. If they miss one, they can't take away your life, your liberty, or your property. This is a wonderful protection if you're ever accused of a crime. The last sentence in the Fifth Amendment, "Nor shall private property be taken for public use without just compensation," is the doctrine of eminent domain, which is not criminal at all. It means if the government needs your property because they're putting a freeway through and you refuse to sell, then they can buy you out anyway in certain circumstances. Now let's look at Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. You have the right to be informed of the nature and cause of the accusation against you, to be confronted with witnesses against you, and to have compulsory process for obtaining witnesses in your favor, and to have the assistance of counsel for your defense. Very interesting in the Sixth Amendment. You have the right to counsel for your defense, okay? In the old days, when people were looking at this, and you were accused of a crime, they said, "Do you have a lawyer?" And you'd say, yes, I do. I'm a wealthy person, have plenty of resources, I have a good lawyer here. And they'd say, wonderful, good. What if you were an indigent person? I don't know that I wrote indigent on this board, but let me do it. If you don't know this word, indigent means poor. It means without resources. If you are indigent, if you have no resources, in the old days, and you were accused of a crime, and they would say, do you have a lawyer? And you'd say, I have no money for a lawyer. And they would say, so sorry. Try to defend yourself if you can. And you were left there. But there was a very important case, Gideon versus Wainwright, in the 1960s. And in this particular case, there was a drifter named Clarence Earl Gideon who was arrested for breaking and entering a pool hall. Not a terrible crime. He asked for a lawyer. This was in the state of Florida. He asked for a lawyer, and he was indigent, and he was denied a lawyer. He tried to defend himself, but he didn't know really what the procedures were in court. He was convicted and sent to the Florida State Penitentiary for 5 years. In the penitentiary, he read up on the law and became what they call in the pen a jailhouse lawyer. He learned so much about the law that he was helping other convicts appeal their cases. And he appealed his case to the Supreme Court. And in this case, Gideon versus Wainwright, he simply contended he felt that the Constitution guaranteed every person the right to counsel for their defense, whether you were poor or rich. And the Supreme Court agreed with him and set down a precedent that everyone should get an attorney in a major felony case. That's something for which you can go to the penitentiary. That carries through today. If you are poor, you can ask for a court-appointed lawyer and one will be provided for you. All right, and then the last thing here, the assistance of counsel for your defense. There was another very important case called Miranda versus Arizona in 1966, and out of this, the Supreme Court gave us what we now call the Miranda rights. And many of you know what these are. You see it on television all the time. If someone is being arrested, the police will generally pull a little card out of their pocket and they will read him or her their rights. I want to read your rights. You have the right to remain silent. You have the right to an attorney. If you do not have money for an attorney, one will be provided for you. But you have the right to remain silent is the major part of this. Anything you say may and probably will be used against you in a court of law, is generally what the Miranda rights say. But they're your rights, not just Miranda. The case was this. There was a man who was accused of rape and murder in Arizona in 1966. And he was arrested at some remote site. And in the police car, coming into the police station, he said things to the police which were used against him in his trial and gained the conviction in that case. And so he appealed the case. He was convicted. He appealed the case and he said, I didn't have counsel at the time of my arrest. And so that was a question for the Supreme Court. How in the world could you provide counsel to somebody in a remote location at the time of their arrest? So they decided, why not have the police be your attorney at that moment? And the police don't just tell you the rights, they read them to you so they don't forget anything. What are they telling you? They're telling you what your due process guarantees are. Okay? Moving on from to number 8, the 8th Amendment, it says this in the Bill of Rights: excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. What is excessive? The Supreme Court has to tell us. They tell us what the Constitution means and what it doesn't mean. So if you are arrested and you're not very wealthy, maybe $1 million bail would be excessive. But for some very wealthy person, maybe $1 million bail would not be excessive at all. So that's done on a kind of a case-by-case basis. But this business about cruel or unusual punishment, many of you have done work on the original intent doctrines of judicial restrainers. What did the Founding Fathers think when they wrote the Bill of Rights? For example, when Madison was talking about this, what was he thinking about cruel and unusual punishments? Well, probably no torture or no burning at the stake or guillotine or something like that. But in general, cruel and unusual punishment is sort of a societal thing. What are the values of the day? Things change. Things that they used to do to people maybe we think are cruel and unusual today. So it's quite subjective for the justices in this way. I think we can say pretty carefully that there is no torture. There is no burning at the stake. There is no skinning alive. All these beheading, all of these horrible things that were done to people in the old days. This is cruel and unusual punishment. But where we're getting interesting cases today on this one is where you're dealing with capital punishment there. And capital punishment is the death penalty. There are those in our society that think the death penalty itself is cruel and unusual punishment. The Supreme Court in the 1970s actually sort of put a moratorium on the death penalty for a while because certain states, when they looked at who was given the death penalty in those states, there's a very important case in the early 70s called Furman versus Georgia. And in that case, they looked in Georgia and they said, it seems like everybody who's getting the death penalty is either poor, a minority, not very smart, or all three. And people who are wealthy and can hire a very hotshot lawyer generally don't get the death penalty. You come in, you're dressed pretty nicely, and it's hard for a jury to imagine you doing a heinous crime, and your lawyer gets you out of the death penalty. So they put sort of a moratorium on it until states kind of rewrote their death penalty laws, and now we have capital punishment again. The court has never ruled that capital punishment itself, the taking of a life, was cruel and unusual punishment. Generally now, most states, if they're going to do the death penalty, will do it in terms of lethal injection. I think one or two states still have a hanging that you can choose, or I think there's Utah, I believe, has a deal where you can actually choose the firing squad if you want it, if you're the culprit in that case. So I'm going to stop here in this mini lecture on number 8, and in our next one, I want to talk about 9 and 10, 2 more amendments in the Bill of Rights. See you soon.